Sabi nung lawyer doon sa mga testigo, we all heard his earlier instructions. Sabi niya, I should sign the will for him. So right there and then, inside that room, the testator affixed the testator's name on the will. Is that a valid will? The answer is no. Because while it was done in close physical proximity to the testator, the requirement of presence was no longer satisfied. Why? The testator was no longer conscious of what was going on. Presence requires not just close physical proximity, the absence of any obstruction, it also requires a consciousness, an awareness of what is going on. Okay? So in that case, the will should not be allowed. Okay. Next point. The presence of the notary public is not required at the time of the actual signing of the will by the testator and the witnesses. Hindi kailangan nandun na yung notaryo publiko. Okay? Ang kailangan na lang doon, testator and the 3 witnesses. Alright. Of course, when it comes to the acknowledgement of the will, syempre, nandun yung notary public. Okay. Next point. The law in Article 805 gives us, in paragraph 3, the matters which are required to be stated in the attestation clause. Okay, so what are these? Number 1, it should state the number of pages used upon which the will is written. Okay. Number 2, it should state the fact that the testator signed the will and every page thereof, or cause some other person to write his name under his express direction in the presence of the instrumental witnesses. And number 3, and that the latter, meaning the instrumental witnesses, sign the will and all the pages thereof in the presence of the testator and of one another. These are the 3 essential things. Okay, so number of pages of the will, that must be stated in the attestation clause. You must state that the testator signed the will and all the pages thereof, or caused some other person to write his name under his express direction in the presence of the instrumental witnesses. And number 3, it must also state that the witnesses signed the will and every page thereof in the presence of the testator and of one another. Now, supposing that an essential fact required in paragraph 3 of Article 805 is not stated in the attestation clause. Supposing that the attestation clause does not state the total number of pages used in the will, will the will be necessarily invalid? Or is it still possible to probate that will kung walang number of pages na naka-state sa attestation clause? If what is missing in the attestation clause can be found in another part of the will may still be allowed. Okay? As long as what is missing can be found in another part of the will. Okay. For example, total number of pages is not stated in the attestation clause. But as happened in one case, in the notarial acknowledgement, the total number of pages of the will is stated. That is substantial compliance. Supposing that the total number of pages is not stated in the attestation, but in the last paragraph of the will, just above the testator's signature, yung sa end ng will. Di ba, usually, ang mga end ng mga dokumento, in witness whereof, okay, I hereby sign this, my last will and testament, consisting of, sinabi doon, 5 pages. Can the will be allowed? Yes. Because while that element is missing in the attestation clause, it is nonetheless found in another part of the will itself. In other words, there is no need to introduce extrinsic evidence. Okay. Supposing that the attestation clause does not categorically state that the testator signed each and every page of the will. Ang sinabi lang, among other things, the foregoing will was signed by the testator. Hindi sinabing foregoing will and each and every page thereof. Sinabi lang, the foregoing will was signed by the testator. Can the will be allowed? The answer is yes, as long as each and every page of the will, in fact, contains the testator's signature. Okay? So, although the attestation clause does not state that the testator signed each and every page of the will, ang sinabi lang is, among other things, that the foregoing will was signed by the testator in our presence. Hindi sinabing, foregoing will and every page thereof was signed in our presence. The failure to state expressly that the testator signed every page of the will may be deemed cured if, upon examination of the will, each and every page thereof bears the signature of the testator. But if what is not stated in the attestation clause is the fact that the testator signed in the presence of the witnesses, nakalagay lang doon, total number of pages, foregoing will has 5 pages, the testator signed the foregoing will and every page thereof, and we, the witnesses, signed the will and every page thereof in the presence of the testator and of one another. What is missing? It does not state that the testator signed in the presence of the witnesses. Kung yun ang defecto ng attestation clause, that defect will not be cured. Will not be cured. Even if you find the testator's signature appearing on each and every page of the will side by side with those of the witnesses. Because the mere fact that the signature of the testator appears on each and every page of the will side by side with those of the witnesses will not prove that the testator affixed his signature in the presence of the witnesses. Okay. Presence is required. If the testator, for example, invites the 3 witnesses to his residence on January 1, and he tells them, I have decided to make my last will and testament, and I want you to be the 3 witnesses. And then he shows them his will. Oh, sabi niya, ito yung will ko. I already signed this. Sabi niya, oh, ito, signature ko yan. Page 1. Page 2, signature ko yan. Page 3, signature ko yan. At the end of the will, yan, signature ko yan. And then he asks the witnesses to sign as witnesses. Is that a valid will? It is not a valid will. The mere admission or acknowledgement by the testator that the signatures already appearing in the will are his is not enough. The law requires that the signature of the testator should be affixed in the presence of the witnesses. If the witnesses were not actually present when the signature of the testator was affixed, that is not a valid will. Even if he subsequently admits to them na pirma niya yung mga yon. Okay. Presence. Testator must sign in the presence of the witnesses. The witnesses must sign in the presence of the testator and of one another. When is there presence? There is presence when there is close physical proximity and the parties are situated in relation to each other in such a way that there is no physical obstruction which would prevent one from seeing the other by simply turning his gaze in the proper direction. I am signing my will on this table. You are one of the witnesses. And, well, you happen to be standing by that door, inside the room, but by the door. And there was a commotion going on in the hallway, and you were looking out. Is there signing in your presence? The answer is yes. The law does not require the testator and the witnesses to actually see each other sign to satisfy presence. All that is required is that they could have seen each other sign. There being no physical obstruction, okay, so that they could have seen each other sign by simply turning their gaze towards the proper direction. That's all that the law requires. So, if the testator signed the will inside the same room with the three witnesses, nandun sila sa same room, while the testator was signing, one of the witnesses was busy watching a movie on television, or was watching the newscast, or was busy texting his girlfriend. Okay. And after the testator has signed, the testator called the witness, oh, turn mo na, you sign. Is there signing in the presence of that witness? Yes. Because he could have easily seen the testator. They were inside the same room, walang physical obstruction. He could have seen the testator sign by simply looking at the proper direction. There is presence. If the testator is blind, how do we satisfy the requirement of presence? Through the use of other senses. What other senses can you possibly use? Huh? The sense of touch. Okay. Hindi naman kailangan na akapin ng testator yung witness habang pumipirma. The testator may, for example, hold the will while it is being signed by the witness and sense through his fingertips, okay, the action being done by the witness. Or the witnesses may give him a running account of what is going on. Oh, Mr. Testator, I am now signing on page 1, I am now signing on page 2, etc. Okay. Sense of hearing may also be used. Other senses. Okay? All right. Next point. Of course, Article 805 says, if the attestation is in a language not known to the witnesses, it shall be interpreted to them. Supposing that the attestation is in a language not known to the testator, should the will be allowed? The answer is yes. While it is not possible to have a notarial will without an attestation clause, nonetheless, the fact remains that the attestation is the act of the witnesses, not of the testator. Okay. Let us assume that it is a 5-page will. Page 5 contains only the attestation clause. Yun lang ang nandun sa page 5.